Is the screen visible? Yes. Is the screen visible?
Yes, sir, visible.
Okay. Okay, so I think we had studied till section 82 in the previous class, 82 and 83. Any doubt whatsoever till here, like till section 82 or 83? Okay. So now the next section is section 84. Section 84 is very interesting in the sense section 84 deals with a situation where a person is suffering from insanity, and when he was suffering from insanity, that is when he committed a crime. Now, the Indian Penal Code gives a complete defense to a person who, under the spell of insanity, has committed an offense. Section 84 is the concerned provision. Section 84 says nothing is an offense which is done by a person who, at the time of doing it. Now, it is very important to understand that the law says that the person must be insane at the time of doing the act. That means जब उसने crime commit किया तब वो insane होना जरूरी है, उससे पहले और उसके बाद are irrelevant consideration. ठीक है? So nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind incapable of understanding the nature of the act. Because he is incapable of understanding the nature of the act, he cannot develop intention. And as a result of this, he cannot be held guilty by the court of law. This is the premise on which section 84 functions. Now, अगर किसी को इंसेनिटी का डिफेंस लेना है तो कौन प्रूफ करेगा कि वो इंसेन है या नहीं है? इज इट द रिस्पॉन्सिबिलिटी ऑफ द स्टेट और इज इट द रिस्पॉन्सिबिलिटी ऑफ द पर्सन हु इज क्लेमिंग टू बी इंसेन? यस क्लास. Right. The person who is claiming the defense of insanity has to prove that he is suffering from insanity. Now let us take a situation. Suppose suppose there is Mr. X. Mr. X is suffering from depression. How he will prove? Through medical history, through acts, through witnesses. Now, Suppose a person is suffering from depression and this person commits a crime. Can he claim the defense of insanity? Yes, class. Can a person who is suffering from depression claim the defense of insanity? He's not insane. Okay. Insanity actually is basically a situation where the mental faculties are compromised to such an extent that a person is not in a position to make a reasonable decision. Now, suppose आपको बहुत तेज गुस्सा है और उस गुस्से में इतना गुस्सा आया कि जिसे कहते हैं ना कि मैं गुस्से में पागल हो गया और मुझे कुछ ध्यान नहीं रहा मैं क्या कर रहा हूं. Can such a person also claim the defense of insanity? No. Very right, Anvisha. Very right, Komal. Manisha. Now, let's take a situation. There is Mr. X. Mr. X को एक दिन रात में सपना आता है कि उनके सपने में कोई आता है जो कहता है कि अगर तुम अपनी बीवी और बच्चे को मार दोगे, if you kill your wife and your son, then you will get a place in heaven. He wakes up in the night, takes a sword and severs the head of his wife as well as his son. ठीक है, दोनों का सर काट देता है. Can such a person successfully claim insanity? What do you guys think? Is he insane or not? Why he's not insane? Just because of dream. Okay. Can any normal person believe one's dream? या कोई भी आम इंसान ड्रीम पर बिलीव करेगा? नहीं करेगा. तो जब नहीं करेगा तो फिर वो नॉर्मल कैसे हुआ? This particular person, if he's believing a dream, that means he's definitely not normal. So he's insane. Wait, Manisha. Okay. Now there are two cases of similar nature. Both the cases belong to prior to 1947. आजादी से पहले के हैं. दोनों केसेस काफी सेलिब्रेटेड केसेस हैं. दो सेम केसेस हैं, वली खान का और एक और है दोनों में सेम फैक्ट्स हैं। एक में जजमेंट कोर्ट ने दिया कि वो इंसेन नहीं है, एक में जजमेंट दिया कि वो इंसेन है। ठीक है। नाउ जिसमें कहा कि वो इंसेन है, उसमें कोर्ट ने ये कहा कि विटनेसेस ने ये कहा है कि वो कुछ दिनों से अजीब सा एक्ट कर रहा था, and that is why his act, which is of killing his own son and wife, is not an act which can be attributed to a person of normal intellect or sanity, and the court held him to be insane, and the defense was given. Years later, in a similar matter, the court said no, he was not insane. Right? The general opinion with respect to this is that he should not be considered as insane. Why? Because you are dreaming and you are doing the killing because you want to attain a further objective. That means you are very much in your senses. Yes? Am I clear? Am I clear? ठीक है, तो इंसेनिटी में जो कह रहा है कि वो इंसेन है, उसके ऊपर रिस्पॉन्सिबिलिटी को प्रूव करे कि वो इंसेन है। दूसरा, इंसेनिटी एट द टाइम ऑफ द एक्ट होना चाहिए, उससे पहले या उसके बाद की इंसेनिटी मैटर नहीं करेगी। अच्छा, what would happen in a case where a person is insane for some time but is not insane for the rest of the period? Then what will happen? Suppose a person is insane for 3 months and for the rest 9 months of the year he's fine. Now, very right, Anvesha. So again, if जब वो बीमार था, मतलब जब वो इंसेन था, उस टाइम पर अगर उसने क्राइम कमिट किया तो इंसेनिटी का डिफेंस मिलेगा, अदरवाइज नहीं मिलेगा। सिंपल। एम आई क्लियर? चलिए तो आगे बढ़ते हैं, 85 पर चलते हैं, सेक्शन 85। व्हाट इज 85? 85 इज 85 एंड 86 आर कनेक्टेड। ओके, 85 क्या कह रहा है कि अगर आपसे कोई क्राइम कमिट हो जाए एट द स्टेज व्हेन यू आर इंटॉक्सिकेटेड, ठीक है। नाउ सेक्शन 85 says act of a person incapable of judgment, that means he became incapable of judgment due to the reason of intoxication. I hope everyone understands what intoxication is. Nasha. Provided the intoxicant was administered to him against his will, without his knowledge, and the intoxication must be involuntary. Just take 2 minutes, just read section 85 and highlight the keywords. Yeah, just highlight the keywords. I hope everyone is reading it. Yes, read everyone. Read or not read? Yes, Manisha, tell me the keywords. Write in the chat box. And everyone else also has to do the same thing. If you have read it, just write down the keywords so that I can understand that where are you guys able to understand it or not. Incapable, judgment, intoxication, involuntary. Involuntary intoxication, ठीक है. Good, Devesh. You just forgot two words, which are against his will or knowledge. No one else has even attempted apart from Devesh, I guess. चलिए. So let's break down the section 85. Section 85 says act of a person incapable of judgment. That means as a result of intoxication, he became incapable of understanding that what he is doing, provided the intoxication that was administered to him was administered against his will. That is, जानबूझ के आपने ऐसा किया या उसकी नॉलेज के अगेंस्ट किया या उसकी विल के अगेंस्ट किया. and the intoxication must be involuntary, मतलब he never volunteered for it. ठीक है, अगर ऐसा होता है then it will not be a sorry, if the intoxication is involuntary or against knowledge or against will, then it would be considered as a defense, otherwise it will not be considered as a defense. Yes, am I clear with this, what section 85 is saying? चलिए ठीक है, now let's take a situation. I had gone to a party with my friends. I don't drink. I call one of the waiters and I ask him for an orange juice. Instead of orange juice, he ends up giving me orange flavored vodka. I get intoxicated, and as a result of it, I end up committing a crime. Will I get the defense? Okay. Yes, everyone. Why? Because intoxication was involuntary. Secondly, it was administered against my knowledge or without having knowledge. Fine. Let's change the situation a bit. I went to my friend's party. He says, today is my birthday. If you are my friend, you have to take a drink. And I take a drink. And I end up committing a crime. Will I get the defense of intoxication? Very right. Now, let's change the situation a bit. I will not get the defense because the intoxication was voluntary. Suppose मैं पार्टी में गया, मैं मुझे ऑब्वियसली बात है मैं ड्रिंक नहीं करता, फ्रेंड की बर्थडे में गया मैं, एंड यू नो लाइक कई बार क्या होता है कि सारे फ्रेंड्स मिलके जानबूझ के आपके मुंह में अल्कोहल डाल देते हैं, और ऐसा किया एंड दे जस्ट poured some alcohol in my mouth. As a result of this, I ended up committing a crime. Will I get the defense? Yes, will I get the defense of intoxication? Direct. I will get the defense of intoxication. ठीक है? I hope now it must be clear that what situations would constitute intoxication and what would not. Section 86 is actually a clarificatory clause with respect to Section 85. Section 86 says what? Offense requires a particular intent or knowledge committed by one who is intoxicated. In case where an act is done, in case where an act done is not an offense unless done with a particular knowledge or intent. That means कोई एक्ट ऑफेंस नहीं होगी जब तक उसके उसमें एक पर्टिकुलर नॉलेज आपको हो या पर्टिकुलर इंटेंशन आपकी हो. वी डिस्कस व्हाट नॉलेज इज, व्हाट इंटेंशन इज इन द प्रीवियस क्लास. Now I'll read the rest of the definition. Now, why this section is there? Can a person who is intoxicated is capable of making a reasoned decision? No, right? If he is not in a position to make a reasoned decision, can he create an intention to commit a crime? No, right? This is what section 86 is. Section 86 is actually an exception to this rule. Section 86 says that if you voluntarily intoxicated yourself and you ended up committing a crime, then even if the crime requires a particular intention or particular knowledge, still you would be held guilty as if you had the desired intention or knowledge despite being intoxicated. Am I clear, or should I repeat? Okay, I'll repeat, Devesh. 86 is basically क्या कह रहा है कि अगर आपने इंटॉक्सिकेशन वॉलेंट्री था आपका और उसके बाद आपने कोई क्राइम कमिट कर दिया, तो हर क्राइम के लिए कोई स्पेसिफिक नॉलेज या स्पेसिफिक इंटेंशन होनी जरूरी है. तो ये माना जाएगा कि आपकी वो स्पेसिफिक इंटेंशन या नॉलेज थी ऑल्दो यू वर ड्रंक. अंडरस्टूड नाउ? So 86 is basically not a defense, rather 86 is a clarification that what will not be a defense to section 85. 87 is a very interesting provision. 87 is more like a voluntary non-fit injury type situation, as we studied in torts. 87 says act not intended and not known to be likely to cause death or grievous hurt done by consent. That means neither you have the knowledge nor the intention, and you have the consent, and despite that some offense has been committed. What does it say? Nothing which is not intended to cause death. That means आपकी intention death cause करने की नहीं है, और ना ही grievous hurt. Grievous hurt is a very serious kind of a hurt, such as amputation of leg or amputation of head. Sorry, not head, hands. And which is not known by the doer. मतलब doer को भी नहीं पता है कि likelihood में death cause या grievous hurt हो जाएगा. ठीक है, तो वो ऑफेंस नहीं होगा अगर जिसने हार्म सफर किया है उसने कंसेंट दे रखा था और वो 18 ईयर से ऊपर का था. यस, 87 क्या कह रहा है? Neither the intention was to cause death or grievous hurt, nor the knowledge was such as to cause death or grievous hurt, but some harm has been caused. Then the person who has committed such harm would not be liable, provided the person who suffered the harm was above 18 years of age and has given consent to suffer such harm. Am I clear with 87? Yes, Manisha, you're not clear? Yeah, what is the confusion, Manisha? अच्छा, there is no confusion. Okay, I thought. Okay, fine. So ठीक है, now let's take the example that I mentioned. ए और जेड हैं, दोनों 18 साल से ऊपर के हैं, और दोनों ने डिसाइड किया कि दे विल फैंसी ईच अदर, तलवारबाजी करेंगे बेसिकली फॉर अम्यूजमेंट, राइट? सो फॉर अम्यूजमेंट मींस you don't intend to cause harm, you neither have the knowledge that you will end up causing some harm, ठीक है? And so this agreement means they have consented to suffer the harm which in the course of such fencing it may be caused without foul play, right? कुछ गलत चीज का इस्तेमाल ना करते हुए आप चोट नहीं पहुंचाएंगे. So this is what 87 is. 88, act not intended to cause death done by consent in good faith for person's benefit. मैं सिर्फ सेक्शन की हेडिंग से समझाऊंगा. 88 क्या कह रहा है? इंटेंशन क्या नहीं है डेथ कॉज करने की, डन क्यों की गई है, इट वाज डन इन गुड फेथ, और किस लिए की गई है, पर्सन के बेनिफिट के लिए, मतलब दूसरे पर्सन के बेनिफिट के लिए. अगर इस सिचुएशन में कोई हार्म कॉज होता है देन इट वुड बी नो ऑफेंस. मैंने एग्जांपल में लिखा है डॉक्टर. एक सिंपल एग्जांपल देता हूं. सपोज I am a doctor, a patient comes to me, I tell him that go and do these tests. He comes back with the reports and I say to him that brother, you only have 1 month left, you will die soon, within a month, because you have brain tumor of advanced stage. Hearing this news, he suffers a heart attack and he dies then and there only. Can I be held liable? I am the doctor. No, right? So that is exactly what 88 is. 88 is act done by a person in good faith for the benefit and 88 में एक और एग्जाम्पल है. ऑपरेशन जब करता है डॉक्टर तो उस पर भी वो कंसेंट फॉर्म भरवाते हैं आपसे, ठीक है भैया, अगर कुछ हो गया तो हमारी जिम्मेदारी नहीं है. सो दैट इज ऑल्सो अनदर एग्जाम्पल ऑफ सेक्शन 88. 89 is an extension of 88 only. The only difference is it is applicable only to a child. एंड बिकॉज चाइल्ड है तो 18 साल से कम उम्र का है या इंसेन पर्सन है, तो कंसेंट किसका होगा? गार्जियन का होगा. 89 says what? However, it does not extend to causing death or grievous hurt or abatement to cause an offense. 89 is basically saying कि अगर आप गुड फेथ में बच्चे के बेनिफिट के लिए कोई चीज कर रहे हैं गार्जियन के कंसेंट के साथ, तो उस सिचुएशन में भी कोई ऑफेंस नहीं होगा. लेकिन गार्जियन कंसेंट नहीं दे सकता किस चीज का? डेथ कॉज करने या ग्रीवियस हर्ट कॉज करने के लिए या कोई और ऑफेंस करने के लिए, ठीक है? सो दैट इज व्हाट 89 is. Is 89 clear? It's a very simple and rarely used section. Is 89 clear? And 88 is also clear. Can a lawyer be an example of this, sir? Which Manisha? What crime can happen through lawyer to his client? In the case of a doctor, it is understandable that yes, he might be operating, so there are chances that death may take place or some injury may take place. But in case of a lawyer, I really doubt. हाँ, एक सिचुएशन हो सकती है, मान के चलिए आपका क्लाइंट है और आपका क्लाइंट है और आपने उसको खबर दी कि भाई कि तेरे को फांसी की सजा हो गई है, ये सुन के वो बेहोश हो गया और फिर आपने उसको थप्पड़ मार के बेहोशी से जगह है, मे बी दैट कुड बी वन ऑफ द एग्जांपल आई कैन थिंक ऑफ. Getting it? $90. Consent known to be given under fear or misconception. Consent known to be given under fear or misconception. Uh, I put a gun to Mr. X's head and ask him to sign the paper. Will it be a consent? No. Right? So section 90 is actually a clarificatory clause which says that if the consent is given under a fear or misconception, then it will be no consent. ठीक है? One of the most interesting cases where consent is obtained on misconception are the cases of rape, where people are in a relationship and the the male or the male in the relationship says that I will marry you, and on that pretext he makes the women enter into a intercourse with him. That would also not amount to any consent. Why? Because the consent that has been obtained for such an activity was under a misconception, and hence it would be no consent, right? Similarly, putting a gun onto someone's head, again no consent. Similarly, I show you something but it turns out to be something else, right? Especially it happens in the case uh, of property selling, right? So that can also come under section 90. Section 90 is not a defense but is rather is a clarificatory clause which says that आप अगर fear है misconception में अगर आपने consent दिया है तो it would not amount to any consent. Yes, is it clear? 89 and 90. Just a quick query. Do you guys have these slides as well with you? Yes sir, no? Komal, no, no. Do you guys have these slides available with you, like in your WhatsApp group or like reading from? No, fine. I'll share it today. I'll share it today after the class on the WhatsApp group. Forget 91. 91 is of no use. It is just there. But 91 is basically saying what? I'll just explain. Not much of a relevant section for the purpose of एग्जामिनेशन. 91 says कि वो एक्ट्स जो कि अपने अपने आप में ही एक क्राइम है, तो वो 87, 88 और 89 का जो एक्सेप्शन है वो उनके ऊपर एप्लीकेबल नहीं होगा. दैट मींस इफ समथिंग इज अ हार्म बाय इटसेल्फ, देन it would be, then 87, 88, 89 would not come into picture. For example, I'll just give you an example. Suppose there is a patient who has gone for a checkup to a doctor, and the doctor, on the pretext of medical checkup, does certain things which amount to sexual harassment. Then can you say under 88 that you have consented, so I can do whatever I want to? No, the answer is no. Why? Because if something is prohibited by law, it cannot be done even by consent, right? So that is what 91 says. 91 says that if something is an offense by itself, then 87, 88 and 89 would not come into picture. Yes, is it clear? 91. And then 92 is acts done in good faith for the benefit of a person without consent. 89 क्या था? Act done in good faith for the benefit of a person with consent. 92 on the other hand is act done in good faith for the benefit of a person without consent. Now, in normal circumstances, what would you do? Will you take the consent or you will not take the consent? Yes, class. What would you do in normal circumstances? You will, right? You will take the consent. So one thing is for sure that then 92 would only come into picture when it is not possible to get the consent. Yes or no? So suppose there is an open heart surgery that's taking place. The patient is on the operation table, and suddenly the doctors find something much more important इन द बॉडी ऑफ द पेशेंट की पहले उसको ट्रीट करना पड़ेगा, उसके बाद ही हम सर्जरी कर पाएंगे. तो विदाउट कंसेंट वो उसको भी ट्रीट कर देता है. नाउ कैन यू से कि भाई मुझसे तो पूछा ही नहीं आपने, राइट? दैट्स नॉट द केस. Here it's pretty much sure, pretty much clear that once there is an emergency, then in that situation it is not always necessary to get the consent. एक सिचुएशन लेते हैं, मान के चलिए एक इंसान है, उसको शेर पकड़ के ले जा रहा है, आपके पास गन है, आपने फायर किया so that the tiger may be killed or the lion may be killed, but the bullet ends up hitting the person and the person dies. Can you get the defense under section 92? Yes. Everyone thinks yes. What about Upasana says yes, Manisha says yes, Komal says yes, Anvesha, Krishika Harshini also says yes, Devesh. Okay, fine. Yes, the answer would be yes. Why? Because the act was done in good faith for the benefit of the person without consent, or because the it was not possible to take the consent. 93 communication made in good faith. Again, आपने कोई चीज अच्छे रीजन से बताई लेकिन इंसान उस चीज को बर्दाश्त नहीं कर पाया एंड सडनली डाइज. So sometimes there can be situations such as doctor telling the client, telling the patient that you're suffering from a disease. So 93 would come into that situation. The 94 is act to which person is compelled under threat. Now 94 is क्या situation है कि किसी व्यक्ति को आपने कंपेल किया थ्रेट में, मतलब आपने उसको धमकी दी, थ्रेट दिया कि अगर तुमने ये नहीं किया तो आई विल कॉज दिस डैमेज टू यू. Then also in that situation it would be a defense if you commit any crime. However, there are only two exceptions to this rule, that is murder and offenses against state. आप किसी की जान नहीं ले सकते जस्ट बिकॉज आपको ये धमकी दी थी अगर तुमने इसको नहीं मारा तो मैं तुम्हें मार दूंगा. सो मर्डर के केस में आपको ये डिफेंस नहीं मिलेगा. दूसरा ऑफेंसेस अगेंस्ट स्टेट. किसी सोल्जर को मान के चलिए आपने पाकिस्तान ने पकड़ लिया, सोल्जर को कहा तुम अपने स्ट्रेटेजिक लोकेशंस के बारे में हमें बताओ अदरवाइज वी विल किल यू. एंड ही सेज ओके फाइन आई विल टेल यू बट यू लीव मी. And then when the strategy locations were revealed to Pakistan, they attacked it, etc. Can he says that I was under threat? The answer is a no. So offenses against state, that means सरकार के खिलाफ कोई ऑफेंस नहीं किया जा सकता. सिमिलरली सीरियस ऑफेंसेस जैसे कि मर्डर में भी आपके पास कोई डिफेंस नहीं रहेगा. I think it's a very much of a similar situation. I don't remember. There was some movie recently, some where the hero kills the heroine or something. I'm not able to recall the name of the movie. I think it's so. I think Siddharth Malhotra perhaps was the one of the actors. So very much of a similar kind of a situation. Yeah. So we have one movie buff, Prarthi. Marjava. Yes, I think Marjava is the name of the movie. Ritesh Deshmukh is also there, I guess. Yeah. Right. So exactly. So where he kills the actress, right? That particular scene. Slight harm or rule of trivial. It's not trial, it's rule. So slight harm क्या है कि मान के चलिए आप अपने फ्रेंड के साथ जा रहे हैं, suddenly you just hit their, not hit but you just bang their head from behind कि और भाई कैसा है, ठीक है. So that is like slight harm. Similarly मान के चलिए दो लोग, you two people are walking in a crowded place, so obviously their shoulders would strike against each other. That is against slight harm, that is no offense, right? So 95 says अगर कुछ छोटा मोटा harm हो रहा है हल्का फुल्का सा तो वो कोई harm नहीं है और criminal law situation में नहीं आएगा. Yes, is it clear 95 तक? Any doubt from 76 to 95? Right. Let's move to section 96, private defense. Now, private defense is a very interesting defense. It so 96 to section 106 deals with private defense. Private defense is a very interesting defense in the sense that it is the only defense perhaps which allows you to take someone's life and still you will not be held guilty if you acted in private defense. 96 says 96 is an absolute provision. What does it say? Nothing is an offense which is done in the exercise of the right of private defense. No matter what you do, what offense you commit, if you were acting in your private defense, no offense whatsoever. Right? It's an absolute provision 96. Now, because the provision is so broad, is so wide in its application, so there are certain limitations also that are imposed by law. That in what situations private defense can be successfully be claimed. The first limitation is that your right of private defense is only available when there is a reasonable apprehension of injury. राइट सो पहली चीज तो एप्रीहेंशन होनी चाहिए इंजरी की. दूसरी चीज द एप्रीहेंशन शुड बी इमीडिएट. दैट मीन्स it must be right there in front of you. The second limitation is that the right of private defense has to be in proportion to the harm inflicted or the harm apprehended. In simple terms, it means ईंट का जवाब ईंट से ही देना है, ईंट का जवाब पत्थर से नहीं देना है. Now suppose I had gone to hit you with a gun. Can you shoot me down through a cannon? Can you? Obviously no. If I have gone with a gun, you can hit me back with a gun. But that does not mean कि आप कल को you know nuclear missile ले आएंगे or something of similar sorts. That is completely not permitted. So it has to be in proportion to the harm that could have been inflicted or to the injury. Third, an attacker or perpetrator of a crime cannot claim right of private defense. One who has started the crime cannot claim private defense. Suppose I had gone to hit Mr. X and there I was beaten black and blue, and then I killed him. I killed Mr. X. And then can I say, I acted in self defense? Why? Because he was about to kill me. The answer is a no. Why? Because I started the crime. I started the crime by going to his place with a lathi or with a gun or whatever. Right? And remember that private defense is a shield and not a sword. What do I mean by this phrase? That private defense is a shield and not a sword. क्या लगता है कि private defense is a shield and not a sword? That means what? It empowers you to protect yourself, but it does not give you the power to commit a crime. Am I clear? It empowers you to protect yourself from any crime being committed against you, but it does not give you the license to commit a crime on the pretext of private defense. Now, 97. 97 says, what are the types of private defense that are available? Private defense is of two type under the Indian Penal Code. Private defense of body and of property. अब किसकी बॉडी और किसकी प्रॉपर्टी? सो पहला जो है क्लॉज वो क्या कहता है? खुद की बॉडी और किसी और की भी बॉडी अगेंस्ट एनी ऑफेंस अफेक्टिंग द ह्यूमन बॉडी. वेरी सिंपल. ओन बॉडी और बॉडी ऑफ अनदर. So suppose somebody is about to kill Mr. X. I saw it from my balcony. Can I shoot the shooter? The answer is yes. Why? Because Mr. X is under a direct threat of being killed. So खुद की बॉडी एज वेल एज साइड मतलब किसी और की बॉडी को भी प्रोटेक्ट कर सकते हैं. दिस इज डिफरेंट फ्रॉम लॉ ऑफ टॉर्ट्स के अंदर जब हमने प्राइवेट डिफेंस पढ़ा था, क्योंकि वो कहां तक रिस्ट्रिक्टेड था? ओनली टुवर्ड्स वन सेल्फ. 97 clause 2, the property whether movable or immovable of himself or of any other person. Now second है किस चीज के अगेंस्ट हो सकता है? प्रॉपर्टी के अगेंस्ट भी आपका सेल्फ डिफेंस का राइट, सॉरी प्राइवेट डिफेंस का राइट रहेगा. किस टाइप की प्रॉपर्टी? बोथ मूवेबल हो या इमूवेबल हो. किसकी? खुद की और किसी और की भी. ठीक है. और किन ऑफेंसेस के अगेंस्ट? थेफ्ट, रॉबरी, मिसचिफ, क्रिमिनल ट्रेसपास और इनमें से किसी भी चीज का अटेम्प्ट. ठीक है. Yes, 96 and 97 both are clear. Then comes 98. 98 says कि you have a right of private defense against an act of a person of unsound mind as well. Right? So suppose there is a mad person who is running behind you to kill you with a sword in his hand. You end up shooting him. Right? You will have right of private defense, although that person of unsound mind can never commit the crime in the eyes of law. But still the law empowers you because private defense is available against any sort of danger. It does not distinguish whether the person was capable of committing the crime or not. The moment there is an apprehension of danger in the mind of the person, that very moment your right of private defense would begin. Am I clear? $99. 99 says किन situations में आपके पास right of private defense नहीं है. Just read this. I have, given a pointed submission with respect to section 99. Just read this. Just take 2 minutes and read. Yes, read everyone. Right. What does it say? 97 is again basically nothing but just a limitation. Sorry, 99. 99 says किस सिचुएशन में आपके पास राइट ऑफ प्राइवेट डिफेंस नहीं होगा, जहां पर रीजनेबल एप्रीहेंशन नहीं है किस चीज का, डेथ का, ग्रीवियस हर्ट का। पब्लिक सर्वेंट की एक्ट अगर वो गुड फेथ में कर रहा है लेकिन वो फियर कॉज ना करे किस चीज का, डेथ या ग्रीवियस हर्ट का। थर्ड बहुत इंटरेस्टिंग है, नो प्राइवेट डिफेंस इन केसेस वेयर देयर इज टाइम टू हैव रिकोर्स टू प्रोटेक्शन ऑफ पब्लिक अथॉरिटीज। मैंने मिस्टर एक्स को कॉल किया कि तुम मुझे कल शाम के 5 बजे तक 1 करोड़ रुपए पहुंचा देना, अदरवाइज आई एम गोना किडनैप योर सन टुमारो इवनिंग। I go and shoot Mr. X, thinking that before he's gonna kidnap, I will just go and finish this man. Will I get the defense of private defense? No. Why? Because there is no reasonable apprehension. And I have time to take help from public authorities. Remember what I said in the beginning of private defense, that private defense is a shield and not a sword. Then comes 99, clause 4, which is जहां पे आप ज्यादा हार्म आपने कमिट ज्यादा हार्म कॉज कर दिया, इंजरी जितनी थी उससे ज्यादा। ठीक है, सपोज आई स्लैप्ड मिस्टर एक्स एंड मिस्टर एक्स एंड्स अप शूटिंग मी। ठीक है, शूटिंग मी डाउन, सो ऑब्वियसली बात है दैट वुड बी रॉन्ग एज वेल। कैन यू एक्सप्लेन क्लॉज 2? Who is this? Clause 2. Somebody said clause 2. Which clause? 99 clause 2. Who is this? Not able to. Manisha. Okay, yeah. So clause 2 basically says act done by act done by a public servant. मैं मिस्टर एक्स एक क्रिमिनल है उसको पकड़ने जाता हूँ, आई एम द पुलिस वाला। मैंने उसके घर के बाहर जाके बोला कि भाई मैं तुम्हें अरेस्ट करने आया हूँ, अपने आप को सरेंडर कर दो, तुम्हें चारों तरफ से घेर लिया है। He starts firing at me and he ends up killing me. Will that criminal get the right of private defense? Yes, Manisha. Right now I think it is clear to you. Let's go to 100. 100 is very important, very interesting. 100 says किन सिचुएशंस में आपका प्राइवेट डिफेंस एक्सटेंड करेगा, कहां तक, डेथ कॉज करने तक। स्पेसिफिक है, केवल 6 सिचुएशंस हैं आईपीसी के अंदर जिसके अंदर आप प्राइवेट डिफेंस के दौरान, प्राइवेट डिफेंस की वजह से यू कैन कॉज डेथ ऑफ अनदर पर्सन। नाउ जस्ट सी हाउ the phrasing of the 7 situations has been made. Each act starts with the word assault. Now, why the word assault is used here? Can anyone explain? Can anyone explain why the word assault is used here? Yes. Assault is the only offense wherein the which begins the moment there is an apprehension of danger in the mind of the person. Getting it? So your right of private defense begins the moment you have fear of danger, and the danger must be instant or immediate. That is the reason why in all the seven situations, the word six situation assault is used, and in seventh also attempt is used, which is again kind of a assault only. So first is assault that may cause reasonable apprehension of death. तो अगर आपको death का apprehension है. Second is grievous hurt का apprehension है. Third is assault with the intention of committing rape. So the moment there is an assault with the intention of committing rape, then also you have a right to causing death. Have you guys seen the movie Drishyam? The first one. I haven't seen the second one. Right? Have you guys seen the movie? Anyone who has not seen the movie? So if you've seen the movie Drishyam, then the main story is basically that there is a killing that has taken place. That killing was done by the daughter of Ajay Devgan, right? So the circumstances in which that killing took place was actually that boy was trying to force himself upon the daughter of Ajay Devgan, and in that situation, in order to protect herself, she ends up killing. So she, in that situation, in that same situation, her act is covered under clause 3. ठीक है, क्योंकि वो कोशिश कर रहा था रेप करने की और अपने आप को प्रोटेक्ट करने के लिए उसने उसको मार दिया. So again, her situation would be covered under clause 3 of section 100. Fourth is assault with the intention of gratifying unnatural lust. So if somebody is trying to force having unnatural intercourse, then also person is empowered to cause death. Fifth is kidnapping या abduction हो रहा है और उस सिचुएशन में आप किसी को मार दें. wrongful confinement, आपने किसी को बंदी बना दिया है घर के अंदर, मान के चलिए, उस सिचुएशन में भी. And lastly, seventh was not there originally. It was added after the Nirbhaya incident, when there was a lot of changes that took place in Indian Penal Code. And seventh made it that at, अगर कोई एसिड थ्रो करने की कोशिश करता है तो भी आपके पास राइट है डेथ कॉज करने का. ठीक है. इन 7 सिचुएशंस के अलावा कोई भी और सिचुएशन में आप डेथ कॉज नहीं कर सकते व्हेन द प्राइवेट डिफेंस किस चीज का है, बॉडी का. दैट इज व्हाट 101 इज सेइंग. 101 क्या कह रहा है? व्हेन सच राइट एक्सटेंड्स टू कॉजिंग एनी अदर देन डेथ. तो अगर आपकी एक्ट 100 में फॉल कर जाती है, ठीक है, याद रखिएगा, अगर आपकी एक्ट सेक्शन 100 में फॉल करेगी तो डिफेंस है कहां तक? डेथ कॉज करने तक. 101 क्या कह रहा है? अगर इन ऊपर मेंशन सिचुएशंस जो हैं उसमें अगर आपका एक्ट फॉल नहीं करता है, देन यू कैन कॉज एनी हार्म बट डेथ. (102) just read 102. What does it say? Take 2 minutes and just read. It will automatically clear things to you all. Anvesha, why they were hiding? Because obviously, then how will they'll make the movie? Yeah, just read, everyone please read section 102. Yes. Read everyone. Yes, everyone read 102. Okay, Manisha, what does it say? क्या कहता है 102? 102 is very simple. It says commencement and continuance of the right of private defense of the body. That means प्राइवेट डिफेंस ऑफ बॉडी जो है वो कब कॉमेंस होगा, दैट मीन्स कब शुरू होगा और कब तक कंटिन्यू करेगा. सिंपल है वो. क्या कहते हैं? commences as soon as a reasonable apprehension of danger to the body arises. that means जैसे ही आपको, जैसे ही डेंजर टू बॉडी अराइज होगा, मतलब कोई भी इंजरी का बॉडी को अराइज होगा, वैसे ही स्टार्ट हो जाएगा. और कब तक कंटिन्यू रहेगा? जब तक वो थ्रेट कंटिन्यू रहेगा. एक सिचुएशन करते हैं. I went to kill Mr. X. मैं गन लेके अंदर पहुंचा, but I saw that he was already ready to shoot me down. So I started running back. मैंने वहां से भागना स्टार्ट कर दिया कि भैया मैं मर जाऊंगा अदरवाइज. जब मैं भाग रहा था वापस, तो मिस्टर एक्स ने गोली चलाई और मुझे मार दिया. क्या मिस्टर एक्स को डिफेंस मिलेगा 102 के अंदर? वाई नो उपासना? रीजन भी बताओ. उसने भाग कर मारा, तो डिफेंस मिलेगा या नहीं मिलेगा? मनीषा, मेरा सवाल इतना है. नहीं मिलेगा. Because he was already ready to kill him. No, that is not the reason. Because when he saw that he was ready, that means when I saw that he was ready, I started running backwards कि भैया ये तो मुझे ही मार देगा. तो जब मैंने वापस भागने स्टार्ट कर दिया, तो फिर थ्रेट कहाँ बचा? राइट. राइट ऑफ प्राइवेट डिफेंस कब है? जब से कमेंट्स हुआ. और कंटिन्यू कब तक है? जब तक थ्रेट कंटिन्यू. जब मैंने वापस भागने स्टार्ट कर दिया, सो दैट मींस Now there is no danger to Mr. X. Am I clear? ठीक है, तो जब जैसे ही the moment he starts retreating, that very moment it means that now there is no more danger. Is it clear to everyone? Anyone who has any doubt? Can you repeat, sir? Can I repeat what, Komal? एग्जाम्पल एग्जाम्पल ये था कि मिस्टर एक्स मारने गए मिस्टर वाई को। मिस्टर एक्स जैसे ही मिस्टर वाई को मारने लगे, उन्होंने देखा कि मिस्टर वाई तो ऑलरेडी गन के साथ है। तो ये देखकर मिस्टर एक्स वापस उल्टा भाग गए। जब मिस्टर एक्स उल्टा वापस भाग रहे थे, तब मिस्टर वाई ने उन पर गोली चला दी और मार दिया। क्या मिस्टर वाई को राइट ऑफ प्राइवेट डिफेंस का डिफेंस मिलेगा या नहीं मिलेगा? यस। क्या लगता है तुमको, कोमल? क्यों नहीं मिलेगा? क्यों नहीं मिलेगा? क्योंकि 102 क्या कहता है? राइट ऑफ प्राइवेट डिफेंस कब स्टार्ट होगा और कब तक कंटिन्यू होगा। तो कंटिन्यू रहना भी जरूरी है ना डेंजर का। जब मिस्टर एक्स ने वापस उल्टा भागना स्टार्ट कर दिया, तो क्या कोई डेंजर बचा? नहीं। सो सिमिलरली मिस्टर वाई कैन नॉट किल हिम। अंडरस्टूड? राइट। यस, एनी डाउट क्लास? एनी डाउट whatsoever till 102? अन्वेषा, हर्षिनी, मनीषा, कोमल, देवेश, उपासना, प्रार्थी? Fine. So we'll stop here today, and next class we'll start with. We'll come to that question once we reach robbery. Preparation of robbery is not a crime. Preparation of dacoity is a crime. Right. So we'll stop here, and next class we'll start with section 103 and the other sections. Thank you, everyone.